Hello, welcome to today's immigration tidbit. Okay, well, first of all, you have to understand that they're not placing him in detention. Okay, they're not transferring him to give him somewhere more comfortable to stay. They're transferring him to institute removal proceedings, and they are going to try to remove him from the United States. So, first things first, you need to get legal representation for your husband. He is not going to realistically be able to represent himself any more than someone who commits a crime and believes they can go into criminal court and fight up against everybody and do everything procedurally that needs to be done. So that's the first thing. Next, it is possible to do a bond redetermination hearing if he qualifies. I need to, if I had this case, I'd need to determine if he was under mandatory detention, which he may be, depending on what the crime was. I don't know, what crime he committed, how much time he served, if he pled guilty, if it was a federal or state crime. I'm not sure what immigration has in their, what they call their notice to appear, what they allege against him, whether they believe he's an aggravated felon or not. Keep in mind, if someone is adjudicated to be an aggravated felon and deported on that basis, while there may be a deportation bar that ends, they're inadmissible to the United States for the rest of their lives. So the time to fight this case is now, okay? So that's what I would do first. I'd need to see if he's an aggravated felon, what his grounds of inadmissibility are, if he's found removable, are there waivers, are there grounds of relief, does he qualify for cancellation, asylum, withholding, Convention Against Torture. I need to see what country he's from. I need to see if there's any derivative citizenship issues. There's all kinds of stuff I would have to see, and then, then I would determine a plan to best help him. Now, procedurally speaking, if he's just been transferred within the next 5 days or so, business days, he will be in front of the judge. And if he decides not to fight his case and sign the deportation, depending what country he's from, he could still be in detention for another month before they deport him. So he does not want to sign anything. He wants to go in front of a judge, and he wants to tell them that he wants to get an attorney. Unlike criminal law, an attorney's not appointed for him. He needs to retain his own attorney. But of course, it needs to be an immigration attorney, and the immigration attorney needs to know about deportations and removal. Okay? And so what will happen is once he has the first court and says that it will be set over, he can then do a bond redetermination hearing to see if he qualifies and how much. The judge may or may not grant that. If the judge does grant it, it'll be for a certain amount, and then the case will be set over while he gets that amount and does everything necessary for the bond, which by him I mean you. And then if he's released, the case will be set jurisdictionally wherever he happens to be going. So, if you live in LA, then it'll be set in Los Angeles type thing. And so then there'll be a master calendar hearing. The master calendar hearing will go forward. It's very important, that hearing. Some people think because they're only in front of the judge, 5-10 minutes for the master calendar, that it's not that important, but it's super important. It's the whole roadmap for the whole case. And then there may be a contested hearing, ultimately, a merits, filing hearing. There's all kinds of stuff that goes on. So he may need to do criminal relief depending on what the crime was, and there may be ways to try to get this reduced so that he wouldn't be considered an aggravated felon. All kinds of things that can be done. So you can obviously give my office a call, give you a consultation. Okay?